Good morning, everybody. I'm Andy Bates, Innovation Manager and Intellectual Property Lead at Business West, and a very warm welcome to our autumn webinar and thought leadership series, Innovate 2021, Overcoming Challenges and Building for Growth, supported by Business West and Innovate UK. This series of webinars is running every Tuesday morning throughout the autumn, covering topics from design thinking to funding and finance, leadership, sales and marketing, as well as promoting the wider bespoke support available from us and how we can add value to your future growth plans in what is a challenging business environment. Sorry, Siri just kicked in. Kicking off the programme is a four-part series on intellectual property being delivered in partnership with our colleagues from Ingot. And I'm delighted to introduce Dr. Ian Goodyear from Ingot, who will be our host for this second session titled IP Valuation for Licensing, Making Your Assets Work Harder. As well as Nick, we'll also be joined by Ingot co-founder and CEO, Martin Brassel. So good morning to you as well, Martin. As a participant of Innovate 2021 and subject to Innovate UK eligibility criteria, there will be the opportunity to access our comprehensive range of IP support, including advice from our in-house patent and trademark attorneys, access free of charge to our online IP valuation tool, typical cost £600, and in some cases, access to a £2,500 subsidy towards the cost of an intellectual property audit from an external IP attorney. And that's all subject to meeting Innovate UK and Intellectual Property Office eligibility criteria. But I can discuss all that and next steps and how you access those services at the end of this session. But before I hand you over to Ian, just a couple of little bits of housekeeping that I'd like to take you through. First off, just for on-demand purposes, this webinar is being recorded. Also, your personal video and microphones will not be used unless you're invited to speak by the host. We do have a chat function as well, so you can communicate with other attendees through the chat function, which for this seminar isn't being moderated. And if you have any problems, then please just raise your hand and one of the team will provide assistance. And then finally as well, we do have a question and answer function within Zoom. And if you have any questions, please post your questions there. You can either do it in person or you can do it anonymously, and that is being moderated by myself. But it's just, a little plea is that if you could put your questions into the Q&A section, then that would be great. So without further ado, I'd like to hand you over to Ian, who is going to begin this seminar. Over to you, Ian.
Okay, thank you. Yeah, so as Andy said, I'm Ian Goodyear from a company called Ingot. We're intellectual property specialists, but we're not attorneys or lawyers. We don't do any of the drafting or legal work. We're much more on the business support side of IP, more on what you can do with the IP, monetization, use, exploitation of the assets, rather than the legals around it. So I'm giving a talk on licensing and making your assets work harder. So not only using it yourself, but allowing others to use it for a fee, which really is what licensing is. So what we're going to cover today, first of all, we're going to briefly go over what we mean by IP in this context and expand it out maybe to more to intangible assets more generally as well. What a license is and what it isn't. What the critical elements are to consider when negotiating and agreeing a license with somebody. Which valuation approaches are most useful, and why you might want to value IP if you're considering doing an IP licensing transaction. And then we're going to outline some case studies of some businesses we've helped. They might resonate with you and help you to see how we might be able to assist with Business West to help you get over the line. Licensing is quite complex, so it's it's useful to have some help sometimes. And then we're going to outline our IP valuation offer, which Andy's already briefly mentioned, the online IP valuation, which will be free for you to access via Business West. Before going into some detail, I thought we should outline why we're talking about this and what we know. So Ingot as a team have helped dozens of SMEs, multinational companies, and actually government agencies with trademarks and things they want to license, to devise strategic licensing strategies, to value their intangible assets, to help them negotiate, and really supporting them in their licensing activities. Prior to joining Ingot, all the members of the team, we've got myself, Martin and Alison on the call today. We've all had experience doing licensing before. I had my own technology company and agreed an R&D and licensing agreement for the technology we're developing with a large space and defence prime, for example. Martin formulated and enforced trademark licensing agreements in the previous job, and Alison worked for Enterprise Europe network for over 10 years, specialising in IP on the IPR help desk, for example, and also worked in private practice for a patent attorney firm reviewing licensing agreements. So we've got many years of experience in assisting companies with their licensing. So I said I'll start off by talking about what IP assets we are talking about here and what we mean. So obviously any IP assets that are registered with the Intellectual Property Office or equivalent government office around the world, patents, registered trademarks, registered designs, are right for licensing. In it you have a legally enforceable right, a piece of property there. They're probably the easiest and simplest to license. But there's also other types of IP and intangible assets that often can be licensed. So copyright is the obvious example. This, as most of you probably know, isn't registered. You don't have to fill out any forms in the UK, or UK Intellectual Property Office or anything to get copyright, but often licensed. So software, creative works like music, often licensed. Also literary works as well, sort of, I'm thinking about news feeds, that kind of thing. Contracts as well, quite often licensed, and the license itself is a contractual asset. So if someone's sub-licensing that, that is also included. Resources sometimes can be challenging to license, trade secrets in particular, because you have to tell your licensee the secret, and that makes controlling it and keeping it secret harder. With NDAs and things that may be possible, but it's certainly more challenging. Other resources like know-how, you often see included in licensing agreements as part of a technology transfer, for example, a patent or something. There's often clauses about the licensor helping the licensee to get it all working using the know-how, etc. Relationships sometimes as well are sort of lent out as part of a licensing agreement. Recommendations, less so. Sort of endorsements, ISO 9001 certifications, that kind of stuff, less relevant for licensing. So what is a licensing agreement and what it isn't? Essentially, when you boil it down, a license agreement is an agreement by one company. It's got the assets not to sue somebody else when they use those assets, and for that they want a fee or some other sort of remuneration. So two companies agree. It's a legal contract at the end of the day. One says you can use our IP, the other one says, okay, we'll pay you for that. That's really what a licensing agreement is. But obviously we're going to go into some of the conditions that you often see there. They can get quite complex. Sometimes licensing agreements arise out of a dispute. Somebody thinks that they're being infringed and they settle out of court and they agree past damages and maybe sometimes an ongoing arrangement where they can carry on doing what they're doing, but the company with the IP gets remunerated. Sometimes it comes out of a dispute. Sometimes it's much more amicable. For a licensor, for a company who's got the assets, it can sometimes be a source of new income where you're reaching non-core markets. It might be you're an expert in using your IP. Let's say it's a battery. You're an expert in using your IP for batteries for mobile phones, but your technology might be just as useful for batteries for hand drills, but you don't make hand drills. So license it to a hand drill manufacturer, and you're using your IP more, you're sweating your assets more, and you can obviously limit the use of your IP by application, by territory, and also by time. May cover many relevant rights. So quite often we see agreements where not only is the technology license, but also the name. If you built up a business where you're selling a piece of technology under a specific brand, you can license out both the name and the brand, for example, at the same time. Agreements can be exclusive, non-exclusive, or sole. So to explain that a bit more, an exclusive license basically says you're not going to license to anybody else in the same territory at the same time in the same market sector, so that the company has a monopoly, at least in that sector, in that geography, in that time space. But you can obviously sign many exclusive licenses, for different countries, for example, or different applications. A non-exclusive license basically means that you would license it to anybody who comes along. You would happily license it to a direct competitor of the first licensee. And sole is somewhere in between. It's really an exclusive license, but you reserve a right to use the technology yourself. So you are competing with a licensee with a sole license. Typically, payments are based on sales, turnover, rather than profit. That's because profit is hard to calculate, open to interpretation. But also, quite often we see upfront payments or milestone payments. So, 10 grand paid on sign-in, and another 20 when the first pieces are manufactured, and another 50 when the first sale's made. That kind of, you see those kind of things in agreements. Sometimes the upfront payments are made in cash. Sometimes they're made in shares in the licensor company. So all sorts of different ways that can be sliced up. There's quite often clauses that say that if a licensee doesn't meet certain targets, the license will fall away, or it will change from exclusive to non-exclusive, for example, or there might be a minimum fee that's charged. So, if you don't meet that sales target, we still want, this minimum amount each year. Important to have clauses in there to be able to go into a licensee's business, to send an accountant in there to audit their books, to make sure that they are not, are being honest with you about how many they're selling and what their turnover is from that particular licensed product. Sometimes, obviously, licensees, there's a temptation for them not to be completely honest with a licensor, particularly if they're a competitor and it's come out of a dispute or something. So that's an important clause to have in there. Yeah, so we already said there's right to audit there, and minimum fees and get out clauses. So as you can see already, it's going to be quite a complex agreement there. Thought would show this slide to see how the licensing industry's evolved, both, I'll take you two examples, the software industry and the music industry. So I'm sure you remember in the good old days where software was protected by a license key. So you'd get a physical copy of the software, and you owned that copy, even though you didn't own the copyright obviously in the code, but you would own the actual copy, and to get it to work you would enter a license key. The trouble with this is that license keys were often widely shared on the internet, or clever people made little tools that generated random keys that worked, that you could download and use. So piracy was quite common then. So I think it was Microsoft that then championed use of a license key, but you also had to do online activation. So when you entered your key, it went off to the servers, the Microsoft servers in this case, to verify that you weren't the 100th person that day to use the same code, because if you were, it obviously wasn't a valid code. So that helped somewhat, but again, people found ways to get around that, and there was still quite a bit of piracy. So ways to try and stop that. The first way was to offer your software for free download, and then get people to pay for a service, the so-called freemium model. And I'm thinking here about things like Skype, where you can make Skype calls for free, but if you want to actually call a real phone, you have to pay. Or Dropbox, where you get a bit of space, but if you want more, you have to pay. Those kind of models where you don't mind if people download your software. In fact, you want them to. So piracy issues fall away then, just because of the business model. And since then, it's moved even more so. So now, with a software as a service model, the client, the company, the person using the software, the licensee, never actually has a copy of the software on their computer. They just access it, pay as you go, I guess, on the web. And if they stop paying, they stop having access. So you can see that it's evolved. The whole system has evolved from where you actually had a physical product protected by a license key, much more to a service where you're just paying for access. And music industry's moved in a very similar way, from owning a physical copy of a music right through the digital revolution, where you're owning MP3 files, to now where you don't even own an MP3 file. You just with Spotify or Apple Music, you just buy the right to listen to it while you keep paying. As soon as you stop paying, you have no, you don't have an MP3 file or a CD or anything anymore. You lose your right to listen. So again, moving from a product to a service. Okay, so some critical elements in the licensing deal. The opportunity. So for a licensing deal to be a success, there needs to be an agreed view of the technology application and the exploitation route. And if the opportunity is large enough, material enough, then there should be an opportunity there to do a deal. When you're negotiating, you need to decide whether it's going to be exclusive, non-exclusive, or sole, as we talked about, what the applications, territories, and time periods are, what the IP is as well. Is it just a patent, or is there a trademark involved? Is there know-how that's going to be offered as well. So really defining what the IP is. And what's the basis for a royalty payment? Is it going to be units sold? Is it £5 every time a unit's sold, or is it a % of turnover? Is there an upfront fee? How's that paid? Are there milestone payments? Do the fees vary with the amount sold? You know, you might want 3% if sales are less than £1 million, but 4% if it's more, or, you know, yeah. So how's all that defined? And are you going to, as a licensor, issue an invoice weekly, monthly, yearly? Oh, and you know, these things need to be hammered out. Yeah, I think we've covered the benefits as well. So, but really, it needs to be fair for both sides. Otherwise, one side won't be motivated. And really, a license is a partnership between a licensor and a licensee. So it's important that both sides gain from the agreement, and it's a win-win situation. So I'm going to move over. I'm going to hand over to Martin now to go over the methods of IP valuation.
Thank you, Ian. Good morning, everybody. I hope you can hear me clearly. I know we've had a little bit of an issue with the sound going in and out.
Yeah.
We've just raised this point about making sure that both parties are adequately motivated in the deal. And I know from personal experience that it is actually possible sometimes to do too good a deal with licensing, in the sense that it's great for the licensor, but it's not so great for the licensee. And if you end up in that situation, unfortunately, you're probably not going to achieve the level of return that you would like, simply because the licensee isn't adequately motivated. So this whole question of valuation is pretty important, both in terms of understanding what royalties you should set, and also thinking a little bit more about whether you want to have an upfront and whether this is effectively an advance against royalties, whether it's a separate payment, whether it's something for R&D and so forth. So just to quickly recap, there's three main ways that you can think about intellectual property value. So you can think about cost. So this is either how much would it cost somebody to reproduce a set of assets that you've created, in other words, to start from scratch. How much would it cost to replace a given set of assets with something that does the same job but does it in a different way? So one is very much about doing exactly the same thing in exactly the same way. The other one is, are there alternatives that would achieve the same end but potentially using a different technology, which might be cheaper, quicker to bring to market? So that's cost. The kind of way, if we move on, thank you, Ian, the kind of way that we tend to think about tangible asset values is essentially based on market comparison. We tend to think about, when we're trying to value a house or a car or anything like that, have comparable assets been sold on the open market, and at what price have they been sold? Now, that doesn't happen an awful lot with intellectual property for reasons I think we started to explore in the last of these sessions, and we'll talk a lot more about in the final session on exits. Quite often intellectual property changes hands in connection with the company, together with the company that owns it and produces it. There are a number of reasons for that. So sometimes, to try and market comparisons, what we have to think about is, have businesses that own similar assets actually been sold? Or can we get some kind of, if you like, proxy indicator as to what level of intellectual property value within a business is, by looking at how much investors are prepared to pay to buy into it, or how much companies are prepared to license their assets out for. The tricky thing about intellectual property is obviously that it's always unique to some extent. And so for that reason, quite often we tend to look for the income method, which is the next one, which will come up now. And income is really thinking about, what are these assets going to produce in terms of value in future? And that will be based on their sales, or sometimes based on their profits, or occasionally, if, for example, you're licensing a technology that's particularly efficient into another company, you might be able to express that value in terms of the cost savings that can be generated. So let's just think about the applicability of all three of those. Ian, if we move on to the next slide. So there's some relevance of all three of these approaches, although I would stress that you're typically going to be thinking more about the future income than about anything else, because that's the nature of a license. It's a forward-looking arrangement to be entitled to use an intellectual property set, usually, without being sued. Cost may have some relevance and is worth thinking about, because the motivation for your licensee may be that they want to avoid the cost of developing a particular technology for themselves. They may not have the expertise to do it. The tricky thing to watch about any kind of cost calculation is that it's only truly relevant if it's actually possible for the licensee or for anyone else to reproduce your assets. And possible means both technically possible and also legally permissible. If, for example, you have strong patent protection around a technology that you're using, this is likely to stop somebody else from being able to at least deploy exactly the same solution or anything that's particularly similar to it. Now, what that means is if you're not careful when you apply a cost-based metric to the value of your IP, you can actually, paradoxically, avoid placing a value of the very thing that's most valuable, which is the patent protection that you've put in place. So you end up undervaluing what you have. So there are reasons to think that cost is a relevant metric to use to understand where your potential licensee might be coming from, but it shouldn't be the final determining factor in terms of what you charge. If we move on to market, the really useful information that lots of people use when trying to put licensing agreements in place that comes from the market is the published licensing agreements. These typically are drawn from statutory databases. The richest source of data is actually the Securities Exchange Commission data from the US, which contains information on lots of international agreements that have been reached by companies. And there are specialist databases available which organize and categorize this information in a really helpful way. So you can search for precedents. And since everybody tends to look at more or less the same kind of data sources, there's a little bit of a self-fulfilling prophecy here, because what has been charged in the past tends to be a guideline for what will be charged in the future. The previous historical rates won't be followed slavishly. There will be an element of rating and ranking to cater for perceived differences in the quality and range and extent of the utility and so forth of the IP. But nevertheless, knowing this data is pretty useful. Sometimes in negotiation, it's particularly advantageous to be able to pinpoint one or two specific agreements that you feel are really close to the IP that you're trying to license to someone else. But the thing to bear in mind is that the data that we have available within the market on licensing is only part of the picture. The majority of licenses don't legally have to be disclosed, and therefore it never actually happens. So what we see is not quite the tip of the iceberg, but it's only part of the iceberg. The other thing to bear in mind is that good IP is always unique in some sense. And perhaps most critically, if we move to the income, the focus of the licensing agreement is usually on what are the future benefits that are going to be derived from being able to use the intellectual property rights. So some kind of forward-looking calculation is pretty much essential if you're going to correctly understand what the benefits are. It does, however, help an awful lot if both parties have got a common view of how big the opportunity is, what size it is, and what scope it is. If we move on in. Now, the most popular approach that tends to be used when valuing intellectual property in almost every context is called relief from royalty. And there's a couple of reasons for this. Firstly, that it's relatively easy to understand, and secondly, that it's based on assumptions that are very closely associated with licensing. Just to explain the phrase, because it's a sound a little bit odd, the royalty is the amount that somebody else would have to pay in the market on an arm's length basis, if you will, to obtain access to the IP that's been identified in order to realize, in other words, obtain a given set of cash flows. And the cash flows are what you're modeling in terms of identifying what the total size of the overall opportunity is. So that's the royalty part. The relief part is the amount that the IP owning business, which we're imagining in this scenario would be your own business, doesn't have to pay because you already own the assets. So that's where this slightly curious sounding phrase comes from. It's the avoidance of a royalty. And the way the calculation process works is that future cash flows get translated into a royalty, which is notionally, if you like, generally, how much profit are you actually making? If you're receiving a royalty from someone for licensing out your IP, that should be a highly profitable income stream. So you consider if it's a profit, then it's also taxable, so you have to account for the tax on it, take that off, and then you express a present day value for all of those future royalty income streams using a method called discounted cash flow, which is the generally accepted way of being able to come up with the net present value of any future forward-looking set of projections. Now the key is, what's a suitable discount factor? And Ian, if we bring up the next panel, I can just talk you through a few of the considerations. So the first consideration is, what's the right royalty rate to use? And this is something that we hold on our databases and systems, but can also be looked up with the specialist database I referred to earlier. You know, trying to find royalty rates that have really been charged in the open market, and they do vary quite a lot by sector. To give you an idea, within the scope of our valuation tools, which are the subject of the offer we'll come on to in a moment, it could be anything from as low as less than 2% up to over 10% of incomes. Sorry, by incomes I mean revenues, not profits. So there's a fairly material difference, and these variances are generally sector-based. They depend on the type of technology, they depend on the average lifespan of that technology, how long somebody might be paying the royalties for, how profitable that supply is likely to be. So picking the right royalty rate is important. The next one is working out whether the forecast future cash flows that you're looking at are actually reasonable. Do both parties buy into the fact that the opportunity has been correctly characterized, bearing in mind that you're probably going to have minimums in place where you're going to be holding the licensee responsible to some extent for achieving these income streams. Clearly, it's in their own interest to do so because they're only going to be paying you a proportion of what they earn from utilizing your technology. But nevertheless, they have to buy in and believe that these forecasts are reasonable and achievable. The next question, which is very important for the discount factor calculation, is how much risk is there in these forecasts? Are they definitely going to materialize? Are they all contractually pinned down already? So in other words, is there really very little uncertainty around the fact that these cash flows will materialize? Or are they somewhat more speculative? Is it a brand new opportunity? How strong is the presence of your licensee in the particular market that you're trying to tackle? And there could be legal risk as well. Not all of your IP rights might be granted. Even if they are granted, there might be other people operating in a similar space. And there could be possibilities of infringement. Apologies for the background noise you might be able to hear at the moment. The next question is, what is the lifespan that should be attached to the assets? Because assets always do have a finite commercial life, or nearly always. It's true that the very first trademark ever registered at the Intellectual Property Office is still in force and still being used. It happens to be, I think, the red triangle associated with the Bass beer brand. But normally, whether it's a trademark, a piece of copyright, clearly where it's a patent or a design, there is a finite legal lifespan, and there tends to be a commercial lifespan that's shorter than that legal maximum. So that needs careful thinking about what's a realistic lifespan before effectively the assets become outmoded, superseded, obsolete. And then the final consideration when you're looking at all of these wonderful, racy, exciting future projections of the opportunity is, what's the curve going to be on these incomes? Is it going to shelve, or is it going to fall? Is there going to be a problem in terms of obsolescence in the future? Is this an area of technological developments that's extremely rapid, for example, and new things are coming out all of the time? Doesn't mean that the licensing income stream can't still be very worthwhile and very profitable, but it's important to manage these expectations clearly and well. So I think that's all we were going to say about valuation at the moment. Ian, if you click on, I have a feeling that the next slide is just to point out what the free valuation offer is. So the reason I wanted to mention it at this point is that the two sets of calculation methods that are used are cost-based, which will give you some insights into how your prospective licensee might be thinking about the cost of trying to do something that you already do themselves, but also income-based and specifically relief from royalty-based. So within the valuation reports, you do get visibility of what the range of royalty rates is that our research has indicated are most likely to be applicable to your sector. And I think Andy will go through at the end how you can engage with these. That's all I was going to say. I'm just going to hand back to Ian for a couple of concluding points.
Yeah, thank you. So while Martin was speaking, I was looking at the comments, and I noticed that some people are having trouble hearing me, so I'm going to try and speak up for the rest of the talk. And I also saw one question in the Q&A about what databases hold these royalty agreements and royalty rates. So I thought I'd address that now. The main ones are KT Mine and Royalty Range. There's also other ones like Royalty Source as well that are used. So KT Mine, Royalty Range, Royalty Source. If you put those in your search engine, you should find them quite quickly. So moving on, if I can move on. Yeah, so I just wanted to quickly cover a few examples of how we've helped companies in the past, just to give you an idea of a type of services that are available. So the first company was a small UK SME, an inventor and an investor, and you know, a couple of other people who spent a fair bit of money getting a product working. They had some grants, they had some equity funding, and one of the grants was with a company in the automotive battery sector who want to use their technology for that purpose in a car battery. This company became a subsidiary of a US tier 1 or OEM motor manufacturer, and this large US company expressed that they were obviously funding some of the R&D through the grant. They were you know, part funding it. They expressed a desire to either license or acquire the IP exclusively for use in this sector. So the piece of work we did for this company was we searched for historic licensing agreements in the KT Mine database, looking for precedents that the company could use during negotiation. So we looked at what royalty rates had been charged in the past, so it could point to high ones. What sort of upfront fees were paid and how they were structured, what the exclusivity clauses were like there, how long exclusivity was for, whether it fell away if a company didn't perform adequately, those kind of provisions, what the minimum payments were, what get-out clauses there might be, and whether there were any clause, the company still had to develop their IP, their technology. And so we were looking for clauses where the licensee agreed to fund the R&D of the licensor as well. So, you know, we found those clauses which helped the SME in their negotiations. So that was one example of what we've done. We also worked with a large European multinational manufacturing company who had a range of products, €3 billion turnover, and over 1,000 different patent families covering a range of technologies from batteries through to GPS technologies, a whole suite of two-stroke engine patents, a whole suite of different types of patents in different technology areas. So our job was to to examine these patents, identify which ones may have utility in other sectors using codes on these patents, numbers of citations, and then actually talking to the scientists in this company and the R&D departments to see which ones they thought were had most utility outside their sector and what it might be used for. Once we'd identified those, we researched for potential licensees. We looked at these companies' acquisition appetites. Have they bought other IP in the past? Have they bought small companies in the past maybe as well? Or do they develop all their technologies in-house? We looked at the current product portfolio of these licensees. If they've invested in something that's completely equivalent to a technology that this company had and wanted to license, they may not want to throw all that form of investment away to try something completely different. Whereas if this was a gap in their portfolio, it might be a better fit for them. And we also looked at the IP portfolio of these other companies as well, to see, you know, how active they were, whether they always developed their IP in-house as well, or whether again they had assignments. So basically we researched these potential licensees so a company could approach them. And our third and last slide here on case studies really shows where people have used valuations to help with their IP licensing negotiations. And we've done a lot of these, so I've just pulled out 3 examples here. There was a water and sewage company, a utility company, UK utility company, who'd licensed a water treatment technology to another company, and this agreement had come to an end, and the licensee had said, well, we want to carry on using technology, we don't want to pay so much, this is old technology now. So we did a valuation for the licensor to allow them to negotiate more aggressively and get a higher licensing rate from the licensee when the license will be negotiated. A mobile apps and games developer, small company in Wales. We assisted with their licensing strategy, and you can see a quote there. I won't read the quote out, but the CEO of this company basically found the valuation procedure and extremely useful. They used the same tool that's on offer to you here. So if you're in a similar situation, you too may find it useful. And my final example is a government agency, business support agency, who had a brand for a science park, and a university wanted to use that brand in one of the buildings on the park, I believe, as well. So we had to value this brand and help find a fair licensing rate for use of this name. So as you can see, all sorts of different, very varied regions in very varied sectors, very different sized and organisations, and useful all over. So finally, my summary. This is a long list of things that you're likely to see covered in a licensing agreement. So if we start at the top, important to always define the IP accurately, what's being licensed. You know, you might list one patent but not a divisional, for example. That might cause all sorts of trouble. Also, you have to lay out the scope, whether there's a right to manufacture or whether it's a right to just sell, whether it's a right to use, what territories, what sectors, market sectors are involved, whether there's an ability to sub-license or not by the licensee, whether it's exclusive, non-exclusive or sole, as we've talked about, what the duration is, whether it's the life of the IP or whether it's a shorter duration, whether a licensee can transfer their rights or not. Quite often that isn't desirable from a licensor's perspective. What the exit options and get out clauses might be, what the payment terms are, whether there are provisions that encourage the licensee to make best efforts, whether that's generic or whether it's actual targets or minimum payments, or penalties if they don't meet targets. What the warranties and indemnities are. If you're going to be a licensee, you're going to want to make sure that you're not licensing a piece of IP that may be challenged or may be accused of being infringing, for example. What the infringement terms are. So if someone does accuse a licensee of infringement, is it a licensor who has to defend them? And if the licensor finds someone they think is infringing, who takes the offending party to court, or tries to enforce their rights? Termination clauses, how disputes between licensees and licensors are handled, whether there's sort of dispute resolution, mediation sort of clauses in there. What happens if one or both companies changes control, a merger or a company gets bought out, and what the governing law is. Quite often these agreements between yourself and a party in another jurisdiction. So a sticking point is often you would want to use UK law, English law, but the other party may want to use the law in their territory. So often that's something you don't think of originally, but often is a cause for dispute or negotiation at least. So as you can see, these tend to be quite long, complex agreements. I would definitely say you need a lawyer to help. You can download template licensing agreements, and in fact the UK government has produced a series of these. There's the Lambert agreements, for example, that are sort of model template agreements for a university dealing with a business. And also there's recently some business-to-business agreements that the UK government have put on their website as well, the IPO website. But these things do get complex, and quite often you're going to need professional advice. That's the end of my talk. If there are any questions, I'm going to hand back to Andy to sort of administer this, and if anybody's got any questions, I think they can be unmuted to ask.
That's great. Thank you very much, Ian, and thank you very much, Martin. And yeah, very warm round of virtual applause. And yes, we've got some time for some questions. One from me is around how have you guys got any experience on how you police your license agreement? For example, how do you know that that the other side has had the amount of sales, or that it's the right amount of sales that they're claiming? That kind of thing.
During the agreement of license, it's important to have those right to audit clauses inserted in there. And then if the licensor suspects that the licensee isn't reporting all the sales, for example, they have a right to send someone in to inspect the books. And if the auditor finds, quite often there are clauses that say if the auditor finds that there's more than a 5% discrepancy, the licensee pays the auditor's fees and obviously makes good. Whereas if there's less than a 5% discrepancy, the licensor has to pay the fees. So,
and that's a really nice.
That's the dimension that's probably worth mentioning. This is one of the reasons why minimums are very important to set, because if you're dealing, for example, with a license to, let's just say, a Chinese manufacturer, for example, which is not an untypical scenario nowadays, given where manufacturing tends to take place, you may actually in practice find it pretty difficult to audit accurately what goods are being produced, what goods are being sold. And on that basis, the sort of pragmatic step that many people have taken is to set the minimums at a level that they know they'd be comfortable and feel like they're getting a decent return on their IP, regardless of whether the audit proves practically difficult.
I've got you. That's brilliant. So thank you very much for that, Martin. And because that was a wider question that somebody asked, who would be paying the legal fees? And I guess that's down to whoever wants to bring the action. Is that fair, or would it, like you say, be the smart move is to try and write it into the agreements at the start?
So so with a right to audit, usually the auditor's fees paid by whoever, if there's a problem and the licensee pays, if actually a licensee's been honest, and the licensor usually pays. As for negotiating the licensing agreement, I think both sides need to take legal advice, so they'll probably both be paying their own lawyers. If we're talking about who enforces the IP, let's say that it's all going swimmingly, and then a third party says, writes a nasty letter to the licensee saying you're infringing my IP. Who has to deal with that, whether it's a licensor or a licensee? That really should be written into the agreement beforehand.
Well, I get you. And there's an interesting question that's come through, which was another one that I had down as well, which is around the negotiation process, and just a bit of insight into that, because many people will be new to that as a process. And one of them was around, at what point do you seek legal advice whilst doing the negotiations? I was just wondering if there was any experiences that you could share around that process of negotiation and how that process works.
Yeah, sure. Martin, do you want to pick that one up, or do you want me to have a go?
You cover it, Ian.
Okay. Well, my view is that you should try and at least get started without legal advice. If it all goes amicably, you probably just need a lawyer to look it over at the end. This obviously requires you to have a degree of knowledge, I guess, about what the clauses are and what to look out for. If you don't feel comfortable doing that, then you probably need to bring a lawyer in a bit earlier to support you. There are plenty of specialist IP advisors out there. There are obviously patent attorneys, but there's also IP lawyers as well, who are a different breed of person with a different skill set.
Yeah, and I think one of the things that I'd recommend to everybody is, and you mentioned it, Ian, is around the Lambert agreements, and historically set up for companies looking to go into agreement with universities. But there are now some really good business-to-business ones there, and I'd really recommend that people look at those templates and that toolbox, and familiarise themselves with that.
It's a good education. Yeah, absolutely. Yeah,
that's brilliant. Just picking up from Gianluca, what he was asking, or what they're asking, is that they're repeatedly being told that licensing companies do not attract investment. Is that your experience?
Do I take that one, Ian?
Okay.
So, Jen, I can see you've asked two questions here, actually. So, in terms of the difficulty in attracting investment, I think it really depends on what's that investment for. If you are in a position where you've actually got large existing profitable income streams coming in from licensing activity, then what do you actually require the investment for? If, on the other hand, you are putting together a kind of, let's say, an early stage, a startup proposition where you say that you're going to generate an awful lot of your income through licensing, the difficulty is that you kind of need to prove that you're capable of doing that, and that your IP really does have enough traction to do that before anybody will invest in, for example, helping you build it or complete getting hold of the protection for it. There's sometimes some reticence from investors around investing in businesses that don't actually have, if you like, operational capacity to be able to deliver their own solutions. So I think there are a few reasons for it, but it's probably more about the certainty that the business model will actually work than it is around licensing per se. I mean, licensing in theory is a wonderful thing that every investor loves because it's a way of boosting your cash flows and potentially a possible exit route, in fact, if the licensing stream goes particularly well. So I hope that's somewhat helpful. You also asked another question I can see here about potential licenses being scared off by a rate that was okay for other businesses. I mean, the thing to bear in mind, which we haven't explicitly said in this presentation, is that any license, it's nearly always, but not quite always, calculated on the basis of revenues. And this is primarily because revenues are much easier to measure. They're much less contentious. You can kind of understand and check out, you know, even in somebody's published accounts, which you can get in the UK, how much have they sold. But it's a rather different matter when you try and dig down into profits. Having said that, they always have to be paid for out of profit. And so that means that you can't have a licensing rate that completely eliminates all of the profit that your licensee might be capable of generating. And provided that what you're taking is effectively, if you like, the cream off the top, rather than trying to burrow right down into the basic, you know, fundamental profitability of the business, you should get somewhere. But I think the real answer here is, where possible, look for historical precedent and show that the rate is reasonable based on rates that have actually been charged in your industry in the past.
That's
great.
Somewhat
helpful.
Yeah,
the other thing to bear in mind is the percent of what. So quite often it's a matter of negotiation whether, let's say that you have a technology in a mobile phone, 5% of the price of a whole mobile phone or 5% of the price of the chip in which your technology is being used are two very different things. So quite often, you know, it's usually on a component level. You know, you get 5% of the price of a chip rather than 5% of the price of a whole product that's sold. So that's again quite often a source of negotiation there as well.
That's great. Thank you very much for that, Ian. That's the end of the Q&A session. That's all we've got time for. Lindsay, I'll pick up your question on my closing remarks.